Today is the 25th of November 2020. And if you had a chance to notice, I know I only just put the link out, I chose a rather sensitive topic of Mesira. Now, have you come across this topic? I'm sure you have. Just very briefly, what have you come across on this topic in the past?
Only in Kiddushin, Mesira, with regard to Kinyan.
Right, that's a different topic. You know what I'm talking about, though?
Yeah.
I'm talking about handing people over to the authorities.
Yeah.
Any comment?
Well,
Not particularly.
No. I mean, it's a very hot topic in certain postcodes in London. I mean, E5, N16. You know.
Right.
Mesira is not someone regarded very favourably in those postcodes.
It follows on from the topic we discussed in the past, and last week in particular, we spoke about Dina de Malchus Adina, the simple understanding of which is the law of the land prevails. You live in a host culture, you follow the law of the land. What we said last week, I think is fair to summarize by saying that the whole picture is much more nuanced than that. And an important part of the interplay between Dina de Malchus Dina and Halacha, and perhaps one may say one thing which highlights that there's a certain complexity there, and one has to be careful how one applies Dina de Malchus Dina, is the Halacha of Mesira, of handing over. There's a more elegant English word, isn't there? What would be the right word?
There are some inelegant English words as well.
Okay. I must tell you, and I want to make sure that I budget time for this, one of the things which pushed me to speak about this topic is something that is literally current, something that I'm actually quite actively involved in, and I feel quite strongly about, and that it has very much to do with this topic, but I have to explain it as we go along. So the issue of Mesira. Let's start off with Choshen Mishpat Siman Shin Peiches if Tes, which is the source in Shulchan Aruch for this, and it says also Limso Yisrael Biad Akum. It's forbidden to give over a Yisrael to the hands of Akum, of non-Jewish people, of Goyim. Bein begufay, bein b'mamonai. That means you're not allowed to give over him physically, bein b'mamonai, or even his money. Even if he's a wicked person, and you think, well, he deserves it. No, that's no excuse. Even if he's causing you distress, causing you harm, you can't, for the simple point of gaining your protection, that doesn't in itself, we're going to have to give parameters to this, but basically what's being stated is just to protect yourself from distress, that doesn't allow you to do this. And the source for this is a Gemara, I think it's in the first parak of Gittin. It quotes David HaMelech. David said, Amarti eshmar darki meichet bil shoini. This is the Sma in Sivkot and Chafzain. He says, I said, I have to protect my way from sin in my tongue, from speaking sin. Amarti lefi machzem, I close my mouth. But oid Rasha lenegdim, there's a Rasha confronting me, opposite me. The Ratzalaima, that meant to say, after Rasha lenegdim Tzareni, even though there's a Rasha opposite me, facing me, Tzareni, causing me distress, nevertheless, I've got to keep my mouth shut. Keep quiet towards Hashem, supplicate him instead, doesn't to Hashem. Be quiet, tolerate what they're doing, and Hashem will make them fall. Corpses, Hashem deems it. So of course, we don't have a general approach that do nothing in the face of danger, in the face of problems, and rely on Hashem, because Hashem put us in this world to and gave us a challenge of dealing with it, even though he could deal with it. So that was a major point of creation. And even when it's something that Hashem sees to, still, Avraham Avinu is a great role model for us in that he interfered, as it were, and that was what he was supposed to do. Of course, it's not saying a general rule, never interfere, but it's saying in this particular case, you're not allowed to do that, and therefore there's no choice but to fall back to turning to Hashem and asking for his protection, because one's not allowed to get the protection from the authorities in this particular case, in whatever situation is being referred to there. The Mechaber carries on. There's a Ramah in the middle, as you know, the Ramah is woven into the Mechaber. But if one skips a few lines of the Ramah, it says, anyone who does this, he forfeits his share in the world to come. So it doesn't mince his words. It's quite severe. There's clearly some, again, it evidently has its parameters. Where does it apply? Where doesn't it apply? But where it does apply, it's pretty severe, and better be careful not to do this. You can already see just in the language why this is something that Klal Yisrael were very, very wary of, and there was a tremendous resistance in some of the things that Michael, you were alluding to. You can see that there's been a resistance to accept that it should be done in certain circumstances. Of course, ultimately, that's not an excuse. We have to be big enough to recognize, okay, historically, Mesira is a terrible thing to do. Nevertheless, this situation is different, and we can't afford schlepping and taking 5 years to accept the fact that situation X is different. I do accept that, but I'm just explaining why there's been a certain amount of resistance. And don't forget, some of what we are today is a product of centuries of difficult life, many times in European countries, in hostile governments, where the suspicion of the authorities may have been much more justified than it is today. So that's part of the context in which this appears. Okay, so that's the basic halacha Mesira. So let's immediately go on to, as I say, the crucial aspect is the parameters. When is one allowed to do it? We know that there's some cases one was not allowed to, so when is one supposed to do it? What I just read to you was Sif test. If one looks ahead at Sif Yud base, it says, Kol hamoisa has sibur umitzaron, anyone who himself is, we're talking about the prohibition of being moises, giving someone over to the authorities. But let's suppose this person himself is giving people over, and he's not doing it to one person. He's doing it to the tzibur. Maybe I have to try and explain that, but we certainly see a distinction between someone who's harming an individual and someone who's a threat to the community. If he's doing that, Umetzaron adds the Mechaber, he's causing tsar to the community. Muta lemosroi biyad akum lahakoisoi laosroi or lekansoi. You may then give him over into the hands of the Gentiles in order that they will hit him, laosroi, bind him, imprison him, I guess, fine him. But for the sake of the tsar of an individual, one's not allowed to do that. That's a fundamental distinction. You're doing it because of tsar rabim, tzibur calls it, mitzaron to the tzibur, then one's allowed to hand him over. If it's because of tsar yochid, one's not allowed to. That's the fundamental rule.
Is there a definition of tsar in this context? So
yes, there is a definition of tsar in the sense that there's a point at which the tsar is so severe that it will be mutter even in the case of tsar yochid, because jumping back to Sif test, reordered what I read from here in order to try and clarify this in a logical sequence for us. Here it says, the Davka bedvarim ba'alma, on the earlier Mechaber, where the Mechaber said even if a person was a Rasha and a Balaveros and was causing the person asking the Shaila basically distress, but one's not allowed to hand over that harmful individual. On that, the Ramah says, "V'dafka b'dvarim ba'alma." That's only if it's just things. What do you mean by just things? Things that aren't so bad, I suppose. Avalim mosroi, mutalim mosroi. But let's say he was trying to hand me to the authorities, then I can hand him. The hare yuchal lahorgoi bedin. Because I could kill him. He's causing such a threat to me that I could kill him. But evidently, you see here that if a person is such a severe threat to someone else, I mean, this I suppose was obvious to us. We know the general rule: "Ein davar imed b'fnei pekuach nefesh." Pekuach nefesh, one's allowed to do it. One moment. There's another source here. I think also in the case, there's another case in which one's allowed to kill people. There's that when the Gemara in Sanhedrin around Daf Ein Gimel talks about roidev, talks about someone pursuing someone else, and he may be killed for the protection of the person who's being pursued. That case of pursuit is either pursuit with intent to kill, or pursuit with intent to violate sexually. And for that, it appears one's allowed to kill someone as well. So it seems that it would extend to that as well. So
Mesira would not be a problem in that in those circumstances.
Yeah. What I'm unsure about is whether it extends to every single case. But there's certainly some of those cases it would extend to, and we can cut through a bit later on to the cases which have been of practical interest. And let me come back to that as we go later on. Now, I've divided my notes on this topic into two halves, really. One is the theory, and the second is the practice. Let's quickly finish with the theory. What I've said so far is just the loose rules and the theory of it. But before we get on to the practical application, you have to think for a minute. It's surprising how severe this matter is considered. Now, it's all very well if you would think that Mesira means giving someone over and he's going to be executed or murdered by the Gentiles. Obviously, that's very severe, but it seems to go further than that, because it says here, and I sort of glossed over this language before, but it says here, also limso li Yisrael biyad akum, bein begufay bein b'mamoinai. You're not allowed to hand over Israel. That means handing over his body and even his money. And there's a series of halachas before then. It seems to apply to any case in which one facilitates a situation whereby Gentiles are able to violate the property of another Jewish person. And it's surprising that this is so severe, because it seems that this is more severe than stealing it yourself. You would think, why is it worse to cause goyim to steal someone else's things than to steal it yourself? So that's something one has to think about. There's a fascinating concept that I came across from Rabbi Yitzchak Hutner in Pachad Yitzchak, right in Pachad Yitzchak on Shavuos. Don't know what it's got to do with the Yontiv of Shavuos, but that's where he writes it. And he quotes something from Chaim Volozhiner, and he amplified upon it. It's actually relevant to last week's Sedja, but it's a fascinating idea, and it gives some level of explanation to this. But before I get there, I just want to talk about this point that I mentioned. It says Bein Begufay Bein B'Mamoinai, that the Mesira goes as far as moment as well. 2 points which I think narrow it down a bit and therefore explain it a bit better are, first of all, I don't think it's talking about that the money is owed. The person owes money to Gentiles and doesn't want to pay up, and you find a way of letting the Gentiles take what is rightfully theirs, owed to them legally. Don't think it applies to that. I think it's talking about them stealing it. That's point number one. And point number two, the Sma says in Siv Cotton, a second. Yeah, the Sma asks this question: how could it be that Moisa Momen would be more severe than harming someone's money, someone's property yourself? The Sma answers, Gorami Mazik, it's worse than a Mazik. Why? Because, and let me jump a bit. There's a concept, sometimes one falls into the hands of people, and after one's fallen into their hands, they don't exercise any mercy. So also, a person, let's suppose one starts getting involved with a mafia. And so long as you have nothing to do with them, they may be operating in your neighborhood, you have nothing to do with them, and you leave them alone, they leave you alone. Once you start to become involved with them, then it becomes very, very dangerous. That seems to be roughly what it's like. And it says here, once one's fallen into the hands of Goyim Ein Merachman Alav, Umalilin Alav, Alilois Kolkach, Ad Shaharbe Pa'omim Yovai Alidei Sakonas Nefoshes. The Sma describes that once one's fallen into the hands of Akum, then they will not give any compassion anymore, and that will lead them to slander a person, and often that ends up coming to Sakonas Nefoshes. So the Sma is linking the Mosa Momen, so it's part of a slippery slope towards danger to life. That seems to be how he understands it. But I don't know. That being the case, I'm not sure that this din of Mosa would apply to, I don't know, let's suppose you know that somebody's, somebody's gone on holiday, and you make sure some criminals find out about it and able to break into his house and steal his things, and it's going to be a one-off, and the concept of the Sma wouldn't apply. Obviously, you've done something very wrong. Whether it would be under the full stricture of the din of Moisa, that I'm not sure. The fascinating concept that Rabbi Chaim Volozhiner mentions and Rav Hutner amplifies is this. He says that you find in the beginning of Parshas Toldos that Rivka was very distraught, felt very disturbed. She felt the pain of pregnancy that she had, and some Mefarshim say that it wasn't simply that she had a painful pregnancy; it's the oddity of the pain, the fact that there was that when she passed a Beis Medrash, then Yaakovina tried to get out, and she passed the Beis Avodah Zarah. Esau tried to get out, or various other aspects of great irregularity. Sorry. Can you just excuse me for 3 minutes or so?
Sorry, I was called away urgently. Sorry, I'm back.
We were saying that when Rivka had the pains of her pregnancy, she was eventually told there's something very special and cosmic going on within you. It's actually Shnei Goyim b'vitneich, Shnei Lo'omim mimei ayich yiparedu. You've got two babies inside you, but not only two babies really, but it's a cosmic microcosm of two kingdoms who are going to vie with one another for the future. One kingdom would become strong over the other. Rashi says, they'd be like inversely proportionate to one another. One would rise and the other would fall. And that represents what's known as the kingdom of Israel and the kingdom of Rome. Rome, I suppose, representing, well, Yisrael representing Yisrael and the Torah and what is good in the world, and Romi representing the opposite. And it's a constant struggle between the good and the evil in this world. And Reb Chaim Volozhin says that what's special about the Avera of Mesira is one is sort of stepping onto the scales and helping, one is betraying Yisrael, and by handing over, as it were, to Rome in the context of L'oim Mil'oim Ya'amotz. And that's what's so bad about it. That's why it's a betrayal of the klal, of the tzibur. We know in other contexts that Porish Minat Tzibur is considered a very bad thing. It's one thing to do something wrong, it's quite another thing to betray the klal. Simon, you look puzzled at this concept. You're wondering about this.
We were talking about Shimon Bar Yochai.
Yeah, in Shabbos Daf Lamed Gimel you're talking about.
I'm still thinking through the previous discussion with Michael as well. Sorry.
Right. I'm sure it'll be relevant. I've got about 6 examples to share with you. So you came just on time, Joe, because we went into a little bit of a theory, which we'll sort of re-allude to as we get to practical examples, just in time for that. Okay. I imagine that some of what you've been discussing will be relevant. You'll be better equipped to discuss the practical examples. So let's go on to the practical examples. And we, as a nation, as a community, have grappled with this really in modern times, quite recently, in several aspects. Number one, and maybe the most high-profile one, is because of the rise, presumably, in incidents of child molestation, predators, and such things. It's become clear that this sort of thing that can't be. Everyone knows there is a person or people who are going to sexually abuse children. We know that's something that is cannot be dealt with within the community. These people don't stop because the Rav speaks to them, or because they're not going to get an aliyah in shul and so on. It's much more, in many cases, it's much more pernicious than that. It's much more of a deep rishus or illness or whatever it may be, but lamaisa, they're doing the harm. Now, we mentioned when we laid out the principles, just before you came, Joe, what it says in Shulchan Aruch and Siman Shin Pei Ches in Choshen Mishpat, which is the source of the halachas of Mesira, is that when someone is doing something against the tzibur, then one is allowed to be moised them. So if somebody is harming you as an individual and you think it would be really nice to get them put away in prison for the harm that they're doing you, and let's say the harm they're doing you is somehow fairly mild, that doesn't give you the excuse to get them put away. It doesn't justify. However, if it's tzar to the tzibur, then that is permitted. What is tzar to the tzibur? Well, I suppose exactly this. People who harm the tzibur, not harming everyone at the same time, it means they're at loose, and they'll make a victim out of this person today and the next person tomorrow, and a further person next week. That's what a threat to the tzibur is. Apart from which, when we said that for harm to the individual, one may not be moiser, the Sma says in Sivkot Lamed, V'hainu dafka mipnei tsar da alma. That's only because of general tsar. Avalim mosroi, or when I say tsar da alma, I suppose that's loosely translated as mild or moderate pain. Avalim mosroi b'momoin, v'koshkenim yisroi b'makois v'oinshei haguf. What does he mean? I'm not sure what he means. Mosroi b'momoin. V'koshkenim yisroi b'makois. That means the person does Mesira to him. Okay, we spoke about that before. Let's leave that for the moment. If someone is violent towards you, even though there's no threat to life, then the Sma seems to be saying that does justify Mesira. When we talk about the suffering that happens to people who are victims of child abuse, it's clear that the suffering and the trauma and the harm that it does to them for many years, almost for a lifetime, is of course equivalent of severe physical injury, and so it falls under the level of harm which permits Mesira under both counts, under the count of it being a tzar to the tzibor, and under the count of it being a harm that's extremely severe. I mean, there were people who rather naively started to consider the fact that the idea of there being an age of consent and sexual activity below the age of 16 is completely unacceptable. People say, well, that's a modern thing, because you can see in the Gemara that people got married younger, and it wasn't completely out of the question in the Gemara. You know, in the second parak of Kedushin, it says one mustn't marry off one's daughter to the Ketana. But then Tosfos says, yeah, but we do that because the economic necessity is so great. It sounds like times were different and things were done differently. If things were done differently, then presumably it didn't inflict the intense psychological trauma and damage that it does today. So what may have been in previous centuries is not relevant. We know that it inflicts this harm, and therefore it comes into this header. That's number one. I've got here 6 things. Like I said, I'll pace myself to go through them. Number 2 is one has to be aware that the essence of this head of Mesira seems to be as a protection against the future, not as a punishment for the past. So, at least in theory, and I think it's fair to say that in theory, because I'm not sure how one could, in many cases, I'm not sure one could say, well, this person was a threat in the past, but is not a threat in the future. But if such were to be the case, I can't see that there would be a justification to be moiser someone in order that he be properly punished for things he's done in the past. Maybe an example would be, you know, the famous stories of who was it? Jimmy Savile. People who, after many years, I mean, he was discovered. It was discovered that he'd been an abuser after he died. Is that right?
Yeah.
He got away with it his whole life.
Yeah.
But imagine a person is discovered to have done that, and he's now elderly or severely ill. Let's say he's paralyzed. Well, maybe he's got his punishment from Hashem, but then it's discovered that he did these crimes, and it's tempting to want to have him punished by the law. Not sure that would be justifiable, because I think the justification for Mesira is for protection. Protection, by definition, is something that's going to happen in the future, and not something that happened in the past. One of the cases that got the big publicity of that, it was quite a few years ago, it was about 10 years ago now, that there were a couple of videos of one of the Rabbonim in Stamford Hill and one of the Rabbonim in Manchester. Someone went in with a hidden camera and then took a video, and the person there was speaking about something that had happened to him many years ago. Now again, I'm saying that if we know that when someone is an abuser, it tends to be deeply ingrained, and one is very skeptical of. I mean, the burden of proof is very strongly upon them to show that they have changed. So the fact that it was in the past doesn't necessarily mean it's not in the future. But it is noteworthy that the way it was publicized was that he came about something that had been many years in the past, and it was seen as a great shock that the Rav he had consulted did not, at least initially, want him to go to the police. It's worth noticing that important difference between the future and the past. Point number 3 is, we're talking about harm for the tzibur. He said when you want to be moist to someone because of harm he's causing to the yachid, we said it has to be pretty severe harm. Harm to the tzibur, obviously, by definition, doesn't have to be such severe harm. What is the level of harm to the tzibur that he's doing that will justify it? Is there something so trivial? Presumably there is something so trivial that even though he's doing it to the tzibur, it wouldn't justify having him get into severe trouble. But here the Ramah says, Misha Oisek b'ziyufim. Listen, in Seif Yud Beis, the Ramah says, Misha Oisek b'ziyufim v'chadayma. Someone who is dealing in counterfeit money, so he's busy with forgeries. V'yesh lachush sheyazik rabim, and therefore he might cause harm to the community. Masrin boishalayas, you warn him not to do it, and if he doesn't listen, then they would be allowed to hand him over. Now, what great harm is he going to cause to the community by dealing in forgeries, by producing counterfeit money?
You may, for example, harm tzedakahs or something like that. I suppose someone who was, circulating money around, and then that money was, destined for tzedakah, and he somehow laundered his fraudulent money with that money, and then the charities would lose out or something like that. I don't know.
Right, but if it does, it's causing financial harm, which has sort of ripple effects.
Communal financial.
That's severe enough to allow Mesira. I wonder if perhaps he means he's doing it in a way that eventually it brings suspicion upon the community, and the community members are in danger of being imprisoned by the authorities. It might mean that. I'm not sure. If it would mean that, then it seems like it's setting a higher threshold.
I wonder if maybe it would, the outside world would no longer trust any money from the community.
Yeah.
That would be a sour on the whole community.
Yeah. That also is very severe, they say in
we're back into Hill Hashem territory.
Yeah, it's bringing the whole community into disrepute. That's the third point. A fourth point is something that was back closer to home again. There was a case here in England of no doubt you'll know about, of Rav who did things which were very, there seemed to be pretty good evidence. He was doing things which were pretty improper, but I don't think there was any allegations of anything like child molestation. What was happening was women were coming to see him for help. He was ostensibly advising them or answering their shilas, but in truth, he was somehow taking advantage of them to a degree. I don't believe there was any rape or anything like that, but there was the accusations were that there was very improper physical conduct, physical contact, and the way he was doing was taking advantage of his position. They tend to be simple and vulnerable women, and he was a very persuasive type, and he gained a lot of trust, and therefore they somehow thought that what he was doing was appropriate. Obviously, it's totally inappropriate for a person to be a Rav in those circumstances. But would that justify trying to get that person convicted on criminal ground? I think people did try, but I don't think there were criminal grounds in the end, because was what he did criminal by non-Jewish standards? It was certainly very unprofessional. I mean, no one could remain in a professional position if he was doing that. But I think if imagine a lawyer was doing that, it would be struck off. He'd lose his job. I wouldn't have thought he'd go to prison or anything like that. I don't think it's a criminal activity. It's just activity which causes one to completely forfeit one's profession. Personally, it seemed to me that the attempts to report this person to the authorities and to get him criminalized, to have him hit by the law, I didn't think that was justified. Because
I remember at the time, I'm not a lawyer, but I remember sort of, it was obviously the subject of some discussion in the Kehillah. And I remember saying, I'm not quite sure what he's done wrong in a legal sense. Obviously, absolutely done wrong, but it's not something that is going to be they can be prosecuted for.
But that's why the prosecution failed.
Yeah.
But the attempt to prosecute seemed to have been based on an assumption that what he's done is so bad, it's so terrible, that if we could find a way to get him into prison, we'd be delighted to do that. But I'm not at all convinced that's right. I don't know if that's classed as a threat to the tzibur. Everyone who went there was ultimately an adult who had free choice whether to go. Yes, it was the simpler type of people, because that's a little bit naive to fall for it. There were people who ran away. Somebody I know who had spoken, had attempted to consult with him, and I asked him. People asked her, did he ever do anything untoward towards you? And she said, no, never. He chose who he did it to. And I heard another story of somebody who allegedly, obviously it's only second, third hand, who he started to approach in whatever way. And he said to her, don't worry, no one's watching. And she said, yes, a Sforim are watching. And out she ran. So on that occasion, he had misjudged. But whatever the case may be, what it needed was a warning to the tzibur, which obviously was done. It became very high profile. As far as I'm concerned, if people carry on going afterwards, then they really have only themselves to blame. I can't see why that would be justification to be Moser. That's case number 4. Case number 5 is, and don't ask me how this came my way. I maybe picked up something somewhere in a waiting room for surgery or something, which maybe I shouldn't have been reading. But I saw an article once. It caught my eye. It was a fascinating story. A woman was trying to sue a certain man for rape. What were the circumstances? The circumstances had been, she'd been at a party in a hotel with him. And next thing she knew, they were all drinking. Next thing she knew, it was early in the morning, and she was somewhere she didn't want to be, and he had done something to her. And she said, well, I was under the influence of drink, I was drunk, and therefore what you did was you did something to me which actually is rape. I didn't really consent to it. Now, whether she would win a legal battle or not, I don't know. But what it appears to me is this context, that's a very specific circumstance. It's not a person, we have no evidence that if a person took her took advantage a little bit of the fact that she was under the influence of drink, and she would agree to things that she wouldn't agree to when she was sober. So evidence that this is a person who went around raping women or violently raping women. He just pushed the boundaries of what was real consent and what wasn't real consent. I don't see why that's a threat to the civil. I don't even see why that's a severe harm to it. It's like, if you like, just he civilly wronged her. That was probably okay. I thought it was an interesting situation, not a very usual situation, but an interesting one. Happens to be relevant to this discussion. And the sixth thing, the final thing, Joe, at the beginning of the session, I mentioned that something that I'm involved with, which is really something that's been happening just now and made me want to speak about this topic. And here it is. Here's the current situation. The current situation is this. We all know there's a problem of agunas in Klal Yisrael. And this is something which we have worked very hard to try and deal with. Now, recently, in the last, I forget the dates, in the last couple of decades in this country, there have been some welcome developments in our ability as an establishment to deal with this problem. In particular, two legal things. One was the get clause, whereby a person who was religiously married, I think the Federation and Diane Berkowitz, the friend of Roch, were very instrumental in getting this passed. But there's now a law in this country called the get clause, whereby it applies either way. Any person who married religiously may insist, he has to get his lawyer to put this petition through, but he can insist that there's a religious divorce, the marriage is dissolved religiously before he gets his decree absolute, before he gets his civil divorce. The logic of it being that even though the authorities do not accept religious marriage per se, they don't accept that we can define who's married and who isn't married. Nevertheless, they accept that if between these two parties the marriage was contracted religiously, then it's very reasonable for that relationship should be dissolved religiously as well if one of the parties want, and that should justify blocking the civil divorce if the party, if the man, let's say, who potentially is causing his wife to be an aguna, cares about that, because obviously it's awkward for him in terms of various legalities to remain married to her. That may goad him to want to terminate the marriage religiously as well. So that's a get clause. That's just by way of background. It's not the immediately relevant to the shaila that I have now. The shaila that I have now involves the second mechanism which has been developed or is in the process of being developed in this country. And that is, we were talking about this, Michael, the other day. We're still overdue a discussion. There was
Section 76.
Section 76 of the Serious Crime Act
2015.
Right. Section 76 of the Serious Crime Act 2015 provides that if a person and it has its details, if a person in an intimate relationship or a family member living in the same house, various different situations in which it applies, different but related situations. If he's doing something which is, if there's a pattern of coercive or controlling behavior, that could be deemed as a criminal act, and that could even be prisonable. And what it's being argued is that that a person who withholds a get is, at least religiously speaking, still holding this woman in this intimate relationship. And it's a bit of a stretch because they're not physically, they might have been separated, and they invariably will have been for a long time. So there's no current physical relationship, but the argument is that it's religiously an intimate relationship.
Still controlling, isn't it?
And it's controlling coercive. Yeah, but the law is talking about controlling coercive in the context of an intimate relationship or family members living together.
Yeah.
People are living far apart from each other. But be that as it may, that's what lawyers are trying to push, because they want to have, and probably rightfully, they want to have a tool to deal with aguna situations, and it hit the news in the JC some time ago because it was successful, at least once, possibly twice. The husband was under threat. He had this brought against him, and he eventually capitulated and gave the get, and they saw this as a great success. Now, what concerns me is that there's a current case, and I really want this to become known, because there is a case that I have become involved with during the course of my work, where there is a couple have been separated for an extended period. And the way I would describe the situation is they're at a stalemate in terms of the get. Now, we all are inclined to have immediate sympathy with a wife. Why should a wife not get her freedom? What happened in this situation is that the wife initiated legal proceedings very early on against her husband. The story is that she, when she initiated divorce in the first place, she waited until he left the house for a day or two and then locked him out of the house, changed the locks, which if that happened, she wasn't allowed to do that. That's not legal. You have good representation. She then took it immediately to court. She got an extremely favorable settlement. She ended up with something like with an amount of money that we would all be very happy with. And the story as it's been brought to me, and I've seen it, had a certain amount of evidence to the details of the story, is that she and those who are helping her are pushing and pushing and pushing very aggressively for every last penny that the court has awarded, and going somehow beyond that. I don't want to take too long in explaining the details, they're not so relevant, but it's somehow trapping him, that it could be somehow trapping him that he won't even be able to discharge his obligation to give her the lump sum that he has to give her, and therefore he'll be trapped into an indefinite annual additional penalty of £20,000. The bottom line is that the story as it appears is that he's being dealt with very, very aggressively. Now, she might be very bitter about things that happened in the marriage. We don't really know if one or the other was particularly at fault in the marriage, but a fundamental thing in successful divorces is that you have to leave that behind and move on. And as far as I know, any Rabbonim, Dayonim who are involved are saying it's a great shame that they're so immutable here. What needs to happen is she's got probably much more than a Beis Din would have given her. As far as halacha is concerned, a substantial amount of money, huge amount of money that she's now collecting is not permitted up to halacha, is stealing in halacha. But okay, she's got it. The courts have given it to her. We can't fight that. He's not really trying to fight that either, as I understand, certainly as I've heard him say many times. He just wants to come to the Beis Din to work things out. They can bring it to an end, that she won't enforce a judgment in a way that undersells property that he has, causing a further loss of £300,000 or so. You get the flavor of the story. But what happened was that the most recent development in the story is that she or people acting on her behalf contacted one of the lawyers who's been involved in this campaign, and they have started to press charges against this gentleman on the basis of Section 76 of the Serious Crime Act. And when I heard about this, I was very upset to hear it. I think it's an abuse of the concept. I'm pretty sure that is real Mesira, and it's terribly unethical and terribly unjust. But I'm concerned that they would use the fact that public opinion so strongly gravitates to sympathy to the women, that it's very, very hard to fight that current. And one of the ways you can fight that current is by telling the truth beforehand, which is what I'm doing and what or what I may do to various rabbonim and bring out this story. Maybe there should be public communal pressure against this lawyer to withdraw attempting to deal with the situation in that way. In the context of our discussion, it's
can I ask just on
Mesira.
a small detail, but is the lawyer who's doing this Jewish, or is it just the actual parties involved, the husband and wife?
No, I think he is Jewish. I haven't finished doing my homework in this, but I believe I heard the name in connection with the initial campaign to improve the lot of agunas in this country.
May I say something, Rabbi? First of all, on Mesira, I think it's a topic that if you wish to continue learning the halachos of Mesira in the next session, it's something I'd be very interested in, because I think we've touched
more to say of. Maybe
I think there's a lot. I think there's potentially a lot more to say, because I'm very interested to know. And we were talking about it just briefly while you had to leave the share for a minute. But with Simon and I were discussing whether, for example, Mesira is more applicable in situations where there's a halachic element, or where there is only a criminal element that is a violation of a secular code of law. So if there's a halachic element, so somebody, for example, is, I've just seen something at Shuvah from Rav Moshe, but in a case where somebody was falsifying kashrut labels. So there's clearly a halachic dimension to that, but at the same time, he was enriching himself through fraud and misrepresentation. So the authorities would be interested in such a person. This falls into the second category, the second example that you gave, where you're more interested in the future than you are in the past. So although the authorities would punish him for fraud, if in the future a Beis Din would actually prevent him from any activity to do with kashrus in the community, then you prevented future problems, and that satisfies Rav Moshe on that particular point.
I vaguely remember this too. I didn't remember it till now.
I think it is. I think it is. It's a case in New York of somebody, a case in New York or the counties, somebody falsifying kashrus labels and putting kashrus labels incorrectly on treif meat for the purpose of enriching himself. Very, very wicked act. Secondly,
what does Rav Moshe write? Does Rav Moshe say that it is subject to prohibition?
I think Moshe said that the concept of Mesira would apply in this case, because there's a halachic element that can be rectified or remedied by means of a Beis Din taking steps to prevent this person having a kashrus license in his butcher's shop or wherever he, in other words, that supports
my point. The idea of the
that example, that example does support your point, but that only supports your point because there is a capability of a Beis Din to step in and take the proper steps. So where the Beis Din doesn't have, or where there's no apparatus for a Beis Din to step in, such as in a criminal case where Beis Din doesn't have any jurisdiction. Now, in this case of the kashrus falsification, it does have jurisdiction, but in a case where there's no jurisdiction of a Beis Din, then surely the idea of Mesira being such a huge issur is not something that we can carry forward into the modern day, because in past times, a Beis Din would have been able to deal with an individual who had acted in a criminal way. Also, on the final point, I'm sorry, I will let you have an answer at the end, but you talked about Section 76 just now and whether that was something, that we should be trying to apply in a case of aguna, especially where there are circumstances that are quite complicated, which might sympathize with the man's position. But remember, Section 76, and I'm looking at it on my screen, says that a person commits the offense under Section 76 if they repeatedly and continuously engage in behavior towards another person, B, that is controlling or coercive. So, and at the time of the behavior, A and B are personally connected. Now, you can argue that not giving a get does not constitute the definition of continuously engaging in behavior. And I've spoken to my son about this a couple of weeks ago, because
he's studying law now. Is he studying law now?
Yes, he said, I mean, he's not qualified to talk about it too much, but he understands the concepts of law very well. but not giving a get is doing something by omission, and whether that constitutes actually, under the wording of the Act, repeatedly or continuously engaging in behaviour. How can you say that not giving a get is an engagement in behaviour? It's actually withdrawing from engagement in a certain kind of behaviour. And that's where Section 76 has a
might
weakness.
not have the strength to deal with this.
Yes, exactly.
Yeah, but apart from the point that if you look at the clauses carefully, it's a big chiddush in our vocabulary to apply that to a person doing that from a distance, who's living in a completely different place to her, and it just happens to be halachically having a hold on her. So the lawyer who is dealing with this has been in consultation with me, and I told her, the female, I told her this. She argued this point. I said you've got a good argument, but I told her two things. First of all, I consulted my uncle, who was a just retired criminal judge with many years' experience, and I was quite surprised to hear that he did not think that was such a powerful argument. He thought the courts might well find that the Jewish law reality that this creates in terms of the religious consciousness of these individuals makes it the equivalent to that, notwithstanding the clear arguments that you're saying. But the second thing I said to her, and I think this is, I'm not an expert in how courts work, but the sense I have is courts are very concerned about public policy and about about certain pragmatics of their judgments. And in this case, courts, I'm sure, and any civilized person in our societies is extremely sympathetic to a woman in a situation, extremely critical of a get refusal, extremely aware of how unethical it is. So I think it's very possible the courts may be keen to set an authority to have a get refuser sort of pushed into that law, and once you have authority, then it becomes binding authority. So you see, my point is, it's not so much with real life. My argument is with real life experience in the real world, notwithstanding how one would or would not interpret the pure wording of the statute. When it comes to real life, I would not find it surprising at all if the court would rule that way and thereby set an authority, even though they're somewhat extending.
You mean a precedent? A precedent.
Yeah, it's called authority. And I'm not even sure we'd want to undermine that either, because we want that authority to be there for the future. But what we don't want, in the case like I'm talking about today, I think it's quite rare that such a severe stalemate. It was quite a confluence of a lot of different factors.
Now, it sounds like the tables have been turned from the normal, so to speak. In other words,
very much so, but you only hear it because you came to listen to me for an extended period of time, and the concern is that you put these things out to the public in the manner of propaganda, and you get a whole wave of public opinion.
I put the act in our WhatsApp group, so you can click the link to it. Yeah.
I need to go in a second, but I wanted to ask you if we're going to continue this next time. There was another sort of the opposite to the case you're talking about. I was reading about today in a case in Israel where there was somebody. There's a case in a based in there where the based in refusing to force the husband to give a get, even though he's been convicted of domestic abuse. And they even seem to, at least the way it was reported, that they based in accept, yeah, he's harmed her significantly. But
if they refuse them, I don't know, I'd be interested to see the circumstances, but if the reason why they're refusing is because notwithstanding the past is the past, but if in the future she's so bitter that maybe similar to this situation, she's trying to destroy him financially as revenge, and he's merely saying, look, leave me alone, let's settle this and then give the gap. And the argument is, if he's just trying to get the process done in a sensible way, it is not necessarily to be classed as the get refuse of this type of thing. And very quickly, just before you go, I think we feel a certain tension when we speak about this topic, because if we live in the land, we want to be law-abiding citizens. We don't want to be talking about, well, maybe we should be keeping the law in this case, in that case. And maybe there are times in which we according to the law of the land, we should be reporting. Should we really be considering that we shouldn't? I don't know if in real life there are situations where it's going to be a real conflict. Maybe that's worth exploring. But I just want to say, even in the secular law, there are cases when one reports something to the police, and the police say, look, do you want to press charges? So there is a certain amount of discretion there. Maybe the details should be explored. As to whether we'll carry on this week, so like I say, it depends if the more material, but to a certain extent, it may depend on you, because if you supply me with material and food for thought, I say, what about this and this and that? It sounds like you're already working on it, then by all means send it to me, and it might give me the opportunity to expand this and deepen our understanding. We can, as a team effort, maybe we'll be able to then continue next time.
Thank you very much.
Thank you.
All right.
Thank you.
Thank you.
Thank you very much.
See you next week, please, God.
Thank you.